Good morning, good afternoon, and good evening to everyone who dialed in. Welcome to ACE. ACE is Medisalon's America with China Empowerment Seminar Series. ACE aims to bring together experts and executives in the life science field to systematically introduce fresh ideas, key elements, and share their experience and discuss and conduct in-depth discussions on topics of importance in the pharmaceutical industry today. I'm your moderator for today's webinar. My name is Carson Holm, and I'm the Director of Business Development for Medisalon in the United States. Next slide. First of all, please allow me to introduce Dr. Ma, our Senior Vice President of the Chemistry Department, to give us the opening speech entitled PROTAC Platform and its Application Case in Drug Discovery. Dr. Ma was previously an associate researcher at the Scripps Institute and a visiting scholar at the National Institutes of Health. He received his doctorate degree from the Shanghai Institute of Organic Chemistry and the Chinese Academy of Sciences. Dr. Ma has studied and worked at some of the top academic institutions in China and the United States. In 2018, he joined Medisalon as Vice President of the Chemistry Department. Without further ado, let's welcome Dr. Ma to give the opening speech. Dr. Ma, the floor is yours.
Okay, thank you, Carsten, for your kind introduction. Good morning and good evening. I'm very glad to do a short presentation. My topic is about the PROTAC platform and its application case in drug discovery. So I just have two sections. One section is the introduction of PROTAC platform of Medisalon. Another part is the application case in drug discovery. It's about the EGFR PROTAC. So actually, Medisalon Chemistry Department offers this kind of services like discovery chemistry from the single compound library, and also medicinal chemistry. We can do the SARs, ADD for the synthetic chemistry is the major part of our service. And we also have special expertise like for carbohydrate chemistry, peptide chemistry, and we also have this platform like the PROTAC platform. We just will go through that, and the LITAC, just the derivative from the PROTAC similar. And the other platform is siRNA, and another one is ADC service platform. I think this is both all these three areas are quite hot right now still in the small molecular drug discovery. And the Medisalon Chemistry provides three kinds of services, like fee-for service and full-time equivalent FTE. FTE is our major service section model. Is around over 90% belongs to the FTE, and we also provide with the integrated service. So let's. So we have beyond the earlier mentioned this platform. We also have this LITAC platform, ADC platform, nucleoside, acid drug R&D platform, and we also have fragment-based drug design and structure-based drug design platform, because we have a lot of collections. And we also have provide photochemistry services at the platform. Next. So let's go to focus on the PROTAC platform in Medisalon. This platform includes three parts, like the chemistry, in vivo evaluation, and the in vivo evaluation. And actually, we can do all the way to the IND enabling. So facing these challenges in PROTAC drug discovery, we have our advantages, I think, from this Medisalon platform. Like we provide one-stop shop services. We have a broad experience in design synthesis and validation. We have a fast turnaround time, and also we have a high KPI and productivity. And both with chemistry and biology, we validated over 25 targets. Move forward, we have API CMC and also ADME or DMPK, also the pharmacology toxicity and the IND filing next. So Maxilon has like over 6 years of product experience. Right now, there are over 20 projects ongoing. So we altogether we finish probably like something like 50 projects. So we have 300 dedicated product chemists well trained work on this product projects. And from this experience, we have a lot of collections like over 300 advanced linkers available in our store. And we have other kind of scaffold like over 150 Israeli ligase available ligase ligand available. So facing the difficulty of the product as is molecular weight is around 1,000, like from 700 to 1,300. So we have dedicated chemists and analytics. The chemistry is challenging, and also think that the purification is also a challenging. Not only the dedicated chemistry team, we also have dedicated analytics team, including preparation PRC and analysts. Like we dedicate. So this is another example for our this is Israeli ligase ligand. This is for the nilotinamide and padomide. You can say the left-hand side is the exit halogen, or the amine, or the hydroxy group, or the acid, or the carbon bond with this R group. Right. On right-hand side, we have this kind of carbon bond, like derived. You can use this kind of function group to directly link it with this the POI, the target part. Next. This is a lot of examples for the CRBN ligase. You can say there's different Israeli ligase ligand. You can say this here around 25 examples. You can say this quite other kind of range is recently published, and we have this kind of material available. So with the discovery stage. Yeah, next slide. So this is for the VHR, because both CRBN and VHR are mostly used in product drug discovery. So this is the VHR ligand. So we have different kind of this kind of ligands. Like here is amine, this is oxazole, and this cyclopropyl ring. And you can say here we have a lot other kind of cyclopropyl ring, and here is the other ring close there. So also we have some linked with this peg chain with the acid or either the amine. So let's. Yeah, here is the linkers, like we have an acid linker. All these linkers are with the bis functional groups. You can say here either the amine, protected amine, or the acid, or the amine. This two diamines. One amine is protected, a lot of amine is free. And also the alkene, this can do the click reaction with the azide, can quickly make this kind of product compounds, molecules, and alcohol part. So next slide. Yeah, for the linkers, above is a quite flexible linker. Here is the quite rigid linker, like the spiral rings. Here you can 6 plus 6. 6 spiral 5 and 6 4, this kind of rings. Also we have other kind of spiral rings, like the 4 4, 5 3, 5 4, 5 5, or something like that. Next. This is other kind of not that rigid ring. Actually also used a lot in the product drug discovery. You can say either this with 2 rings or this one more carbon over there, or the cyclopropyl over there. So yeah, next slide. This is other kind of available building blocks, like for the most, I think here most are like the Serbian. Yeah, let's go to the next slide directly. Yeah, the next part is the application case in drug discovery. This topic is about the EGFR PROTAC. So next slide. So we know EGFR is a membrane protein. You can say they have a part out of this membrane and the inside of the membrane. So we think usually think the PROTAC is can degrade the targets in the membrane. So this is a membrane protein. So we still have some argue when we decide with the client, decide the target. So finally, we still go to with this EGFR project with the PROTAC, this modality. So after the project starts, we spend around 10 months to get this through to the toxicity research. You can say from the very beginning of this compound synthesis to the PK, PD, and DMPK, and in vivo pharmacology, and to the toxicity to the PCC stage. When this, we have choose 5 published reference compounds or as tool compounds. We use 10 to 15 FDEs. Within this 10 months, we made 258 compounds, including quite many scaled up to gram for the animal test, like for the efficacy, in vivo efficacy test. We have, yeah, this is the profile of this compound. You can say the IC50, either for the HCC 827, you can say it's just 2 nanomole, and also for the other first generation is the PC baseline, it's also just 5 nanomole, and also for the third generation, it also works there, it's around 35 nanomole. So also work for the fourth generation, like you can say, for the other kind of mutations, the fourth generation also like 17 nanomoles. Yeah, next. So this is the PK. We just show how this kind of PROTAC compounds have this kind of a PK. You can say with this PO, because the IV is very good also. Like for this PO is 10 mg. You can say the T half is around 5 hours, and the AUC here is over 38,000. So and the bioavailability is around close to 50%. So from this rat, the PK is very good, and also for the mice, a lot of free base also is good. Similarly, this is for rat. The AUC is also okay, acceptable. So let's go to the next slide. We also did the dog and monkey. You can do dog. The dog, the T-half is also 13 hours, and the dog is also 15 hours. You can say the bioavailability is around close to 10%, something like that. And go to the next slide. We also did quite many pharmacology. Like here is for the first generation of EGFR. Like this is for HCC 827. You can say this 0.2 mg per kg. It works very well. You can say this one. The body weight is okay. Also for the PCNI, it also works very, very well. So yeah, let's go to the next slide. Yeah, this is for the third generation is NCIH 1935. The positive control is the osimertinib. Actually, the earlier slide, is also use this positive control in the market, the best ones. So yeah, next one. This is for the fourth generation. Actually, right now, as we know, there is no fourth generation drug in market, but in the phase 3, something like that, we use that one of the best compound, so-called is INT7. We compare with that. You can say this also shows this efficacy. Have is also active. Yeah, let's go to the next one. So we also did the mid-ID study. You can say on balance, dogs and mice are very preferred as the relative species to the clinical trial. So we also tested the DRF with the therapeutic windows. You can say here for the mice, it can be 446 times and 110 times. And for the 14 days toxicity study in dog is 145. And this one is 24 times. So overall is over 24 times. So the therapeutic window is pretty good for this compound. So for as a summary, we think this compound is effective for various mutations. So for this from generation 1 or through to the generation 4 of EGFR. So it's very active for this kind of whole sequence of EGFR. So we think it's a quite interesting result. So this project is right now is still ongoing though. I think that's all for my quick presentation. I just give some flavors for our PROTAC platform. Thank you. So you can get this PPT content. Please scan this QR code. Thank you.
Carsten, I think you're still on mute.
Okay. Thank you, Dr. Ma. Today, we are so glad to have Dr. Yang and Dr. Feldstein from the Finnegan Law Group to give us the second seminar of the ACE seminar series entitled Patent Enforcement and Clearance for Freedom to Operate in the U.S. We welcome you both to the ACE program. Could you please introduce yourselves, and thank you.
Thank you. I'm trying to share my screen and it shows I cannot start screen share onto, okay, let me see. Sorry, there's a technical issue. I just can't see my PowerPoint.
Should I try and share?
Yeah, could you please? Because my PowerPoint disappeared. It is not in the options.
You see my screen?
First of all, welcome everybody, and thank you again for inviting us to give a talk today on patent law issues as a series of webinar. We talk about the patent strategy and prosecution strategy, how to get a strong patent to litigate in the U.S. last time. This time we'll continue the discussion and talk about in the U.S. how to enforce your patent and also potentially PTAB post-program proceeding challenges. Mark. We'll talk about those. And please, the next slide, Mark. First of all, a little intro for myself. So I'm right now of counsel at Finnegan, a U.S. law firm on IP matters. And I got my PhD in molecular biology in the U.S. And then afterwards, I did a postdoc at Harvard Medical School, Dana-Farber Cancer Institute to study cancer research. And then I went to law school and then joined Finnegan in 2014. So during the over 8 years at Finnegan, I've been working on multiple litigation cases with Mark. And also I've been involved in a lot of IPR, PGR, post-grant proceedings, along with Mark and other partners. And I have been working on majorly life science and pharmaceutical cases. I work for companies like Eli Lilly, AstraZeneca, AbbVie, GSK, Merck, Novartis, and started companies in China and in the US. And next slide, please. And a little intro of Mark himself. Go ahead, Mark.
Good evening, everyone. Thank you for joining us late on your Saturday. I'm a partner in the Finnegan office in Washington, D.C. I've been at Finnegan for more than 20 years now. I started law school after earning a PhD in chemistry at University of Pennsylvania and a postdoctoral research study also in Washington, D.C. My focus is in the life sciences area, small molecule chemistry, biologics, and I primarily do that in the litigation area that we talk about, district court and also before the patent office in the PTAB.
A little intro of Finnegan, our firm. So first of all, we're an international firm. We have global presence. You can see in the slide here, we have more than 10 offices in different cities in the entire world, including Shanghai. We have a Shanghai office, and DC is our headquarters. We have a lot of IP attorneys here. Next slide. Also, we practice IP law we practice IP law in every aspect, including prosecution, litigation, client counseling, portfolio management, due diligence, and also including antitrust and advertising, trade secrets. So everything related to IP we do, we can provide the service for you. We're the general practice firm for IP. We have in the biopharmaceutical life science practice, we have 145 professionals with a lot of people with advanced degree, including PhDs and master degree in life science before they start the legal career. We also have former Federal Circuit clerks who understand what the judges' thinkings are when they're drafting opinions on patent cases. We also have former examiners from the PTO understanding the rationale of examiners when they're examining the patents for issuance. We have a lot of expertise in the different technical fields, including central core fields for the right now, cutting edge technologies in the life science and the chemistry field. We serve a lot of leading companies around the world, including AbbVie, Eli Lilly, AstraZeneca, Incyte, Otsuka, Vertex, many of them. And we're just giving a few names here to show some names you're familiar with. We also serve a lot of biotech companies in the startup stage or medium-sized companies and support the IP needs in all of the R&D stages. So Finnegan, we have a very robust patent litigation practice. Even in the past 5 years only, we already started or filed over 600 IP-related district court litigation cases. And we have a lot of litigators at the firm, over 250 litigators, including trial attorneys. We also have served over 25 innovative pharmaceutical companies in patent litigation cases in the pharmaceutical field. We also have done over 250 cases related to biotechnology and pharmaceutical aspects, including ENDA cases in the last 5 years. We also have a very top PTAB practice among all the U.S. firms. For example, in the PTAB proceeding, we have already dealt with a total of over 1,200 cases representing either patent owners or petitioners. We have experience in presenting both parties. We also in the chem, biotech, and medical device field, we also have dealt with handled over 250 cases, again on behalf of patent owners or petitioners. And you can see in this slide, our practice is #1 in the US because our total case number exceeds all the other firms in the US, and also we're leading them in the numbers in all aspects. So again, with all the practice experience and the robust practice in many years, now next slide we'll talk about the agenda today. We will have some topics such as the patent enforcement overview of patent enforcement, and also we wanted to talk about the district court patent infringement actions. Mark will cover those issues, and I will then talk more about the PTAB practice in general. Thank you.
Okay, thanks, Yi. So as Yi mentioned, I'm going to give an overview of patent enforcement in the US. It's going to necessarily be high level, but we're going to point out some things that especially foreign companies may not be aware of and how litigation works in the US. And but obviously it's going to be high level because this could be a multi-year course covering how patent litigation actually works in the US. And so you're welcome to reach out with general questions after the webinar too. The structure of patent enforcement in the US and validity challenges has two main branches. Starting on the left-hand side, there's the traditional judicial branches that are part of where they're full-time career judges with lifetime appointments who will hear the case potentially before a jury and cover all aspects of it. They're not specialized in patent matters. Patent matters are just one part of what they do. And that's where the majority of cases historically start. There's an administrative branch on the right-hand side where these are not lifetime appointed judges, but they're part of the executive branch under effectively the president, where they're agencies, the US Patent and Trademark Office, the International Trade Commission, where they make decisions. They're more specialized in the technology, and they make administrative decisions, which are usually a little bit lower standards of proof and evidence. So what happens is no matter where you start, whether you start in the district court, which is very typical, or you start in the Court of Federal Claims, which is a specialized court for suing the government for patent infringement and other things. So if the US government is infringing a patent of yours, or a contractor of the US government is infringing a patent of yours, the only place you can sue the government or their contractor is in the Court of Federal Claims. And so you start there in a normal litigation, and then if you're dissatisfied with the outcome, you can appeal to the Federal Circuit Court of Appeals, which is a specialized circuit court that covers intellectual property matters, patent matters specifically, and a few other specialized areas of focus. This was a relatively new creation in the US court system prior to 1984. The standard appellate system is you start in the district court, let's say in Delaware, and then you would appeal to the appeals court that supervised Delaware. But what happens now is that if you have a patent matter in Delaware and California and New York, it doesn't matter. They all filter into the Federal Circuit Court of Appeals, so that there's a more unified rulings on patent, give a little more certainty in theory to what outcomes you're going to get, rather than different circuits in different parts of the country coming up with different opinions. From the Federal Circuit, if you're dissatisfied with the outcome, you can seek review at the Supreme Court. That's the final court, but they don't have to. You can't have Supreme Court review as a matter of right. So most cases most patent cases end at the Federal Circuit Court of Appeals. The Supreme Court maybe handles 1 to 3 or 4 intellectual property matters a year and then rejects the rest of them. The same sort of structure applies from the administrative agencies. If you're dissatisfied with the decision from the US Patent and Trademark Office, you're dissatisfied with the International Trade Commission, you can, on a patent matter, you can also appeal those to the Federal Circuit with some limitations. How long do these things take? We'll start on the right-hand side. The International Trade Commission, which we'll talk about in a few slides, is a very fast venue. It usually takes about 12 months start to finish. The Patent Office, if you're going to be challenging the validity that Yi is going to be talking about, is also pretty fast. It's 18 months from the very first, when the petition is filed, to when the Patent Trademark Office makes a decision. It's 18 months, and it's a fixed, statutorily fixed time period. The Court of Federal Claims, if you're suing the government, very slow. They don't move fast when you're suing the federal government. District court cases, which are the most common type of cases, it varies a lot. There's no set time limit for how long a district court case can be or should be. Every court, every judge is a little bit different. 2 to 3 years is common, but it's not usually faster. It can often be slower, unless a few places in the US, they go in very fast time period. For all those, again, they go to the Federal Circuit for an appeal. There's no fixed time period for those either, but typically around 12 to 24 months from the filing of your appeal to have a decision. And so, depending on the process, this could be a 2-year process, start to finish, from the original decision to the Federal Circuit appeal. It could be a 5-year process easily too, and some cases go on even longer. So I'm going to talk a little bit more about district court and other judicial infringement actions. And so these are the actions. If you're a patent owner and you think that someone is infringing your patent, then the most typical thing you'll do is you'll sue them in district court. You'll find out where the company is incorporated, where they're selling product, and in that federal court in that state, you'll sue them for patent infringement. And just as an overview of the process, this is the process, very, very simplified from the perspective of the patent owner. So the patent owner has some pre-litigation responsibilities. You can't just start throwing your patent around and asserting your patent without doing a reasonable investigation, both of your patent and its enforceability, and more significantly, that your competitor, that their accused product actually infringes. You have to have a good faith basis and some evidence to support filing a complaint in the first place. You don't have to have fully proved your case at the beginning, but you have to have enough to get in the door, get through the door. And then when you have completed your pre-litigation review and your pre-litigation diligence, the filing of the complaint that you file with the district court and you serve on your accused infringer, that is the formal start of the proceeding. That brings the judicial authority over the case and puts it under their authority for the 2 to 3 years that it's going to happen. After the patent owner files a complaint saying, I have a patent, this is the defendant infringes, here's essentially why they infringe, and here are other related proofs that the court should review the case, there's time for the accused party, the accused infringer, to respond. It's called an answer. They can say, and they usually do, they deny that the patent is infringed or that any valid claim is infringed. And they have the opportunity to have their own counterclaims in return. They can have counterclaims that the patent's invalid. They can have counterclaims asserting their own patents if they have patents. For example, if it's two innovators, one suing another, it may start a bit of a patent war between the two companies. Following the answer and the counterclaims, again, simplified, there's a long process of fact discovery. The US, and we'll talk about this a little bit more, the US is very unique around the world in how much information gets pulled from each party's confidential records and shared with the other side so that each party can develop their case. Following fact discovery, or maybe towards the end of fact discovery, there's usually a specialized hearing where the court construes the terms in the claim. And so patent claims are often complicated in terms of the technology they recite and also the style that patent claims are written in. And sometimes it's not completely clear when you say you're claiming an effective amount of a drug, what does effective amount mean? Is it an effective amount for a human? Is it an effective amount for a mouse? Does it depend on the condition? And so the court will go through a process where both parties present their sides. Here's what the claim means. Here's why it means that. And that can be really critical. The claim construction order that a court gives can be fairly dispositive for how the case is going to result. Typically, the patent owner is arguing for a broader claim construction so that they can capture the infringer. And typically, the accused infringer is arguing for a narrower claim construction so that they're outside the claim and not infringed. Expert discovery, which we're going to talk about, is a big part of patent cases, both district court cases and the PTAB cases that Yi is going to talk about. A lot of it turns on having really good experts that understand the technology and are well prepared and well trained to be able to explain to the court, whether it's the judge or a jury of non-technical persons, what the prior art references mean, what the patent teaches in terms of unexpected results, why they're unexpected, whether it's obvious to combine two antibodies in a treatment together and expect them to work. Ultimately, there's a trial. Depending on the type of the case is either just before a judge or it could be before a jury of just 12 citizens with no specialized technical knowledge, no specialized legal knowledge, and that jury may decide questions of billions of dollars in patent infringement. It's fairly scary, the power of the jury without any training to decide patent matters. You get a final judgment from the court, and then typically patent cases, it could end there, the final judgment, but almost always, unless there's a settlement, the parties appeal. The appeal is a much smaller, compared to the whole litigation, much smaller part. And with the money and the products and the important things that are at stake in these types of intellectual property trials, almost always the losing party tries to appeal to the federal circuit to change the result. I mentioned fact discovery. It's really, really extensive in the US. Most US companies who've not been through litigation don't realize how invasive discovery is. And certainly non-US companies that don't have any experience here don't realize how it is. And so I think this is an important thing for everyone to understand, that if you're in US litigation as either the plaintiff, the patent owner, or the defendant, the accused infringer, you're going to be producing a lot of information from your records. Basically, each party can ask for documents that can say, give me all your documents related to the development of this product. Give me all your documents relating to how you prosecuted the patent. Give me all your documents related to the financial information on how much money you're making off this product. And that can go on both sides, the defendant and the plaintiff, the patent owner, and the defendant, the accused infringer. They can both seek from each other extensive documents, your emails, your IMS messages, anything recorded, they can see copies of. They can see not only documents, but in the category of documents, they can get samples of your products. They can even come and do plant inspections of your facilities to look at your facilities. And many companies have gotten in trouble where they don't produce the documents, or some companies have even gotten in trouble where they think that it's okay to purge their files of emails or information. And you're almost guaranteed to lose the case if the court thinks you've destroyed documents, whether intentionally or inadvertently. Is going to go very badly for you. So you can get all your documents, all your emails between you and your staff, you and your competitors is very, very invasive. Not only can you get existing documents, each side can ask the other party, tell me your position on this. Tell me all the reasons why you think our patent is invalid. Tell me all the reasons why you think the product infringes or doesn't infringe. And that's important because you get the parties to lay out their positions early. And part of the point of doing all this extensive discovery is for there to be no factual surprises at trial. Everyone should know their positions well before trial, and then it's just a weighing of the evidence in theory. A last main section of discovery is depositions. And depositions are formal, sworn testimony recorded by a court reporter, where you can ask the other side, I want to have a deposition of your inventor. I want to have a deposition of your chief engineer who made the accusing product. I want to have a deposition of your financial people. And people with sworn knowledge have to testify on facts they know personally. Or you can even take a deposition of the company and say, company, tell me everything you know about this topic. And again, it's very invasive. It's sworn testimony. It's used for the other side to build their case and used for cross-examination purposes at trial. I want to talk about two specialized areas of litigation, district court litigation in the US that are particularly important for the biopharmaceutical industry. The first one is Hatch-Waxman litigation, which is litigation related to small molecule drugs. And what happens is, an innovator develops a new small molecule drug. They file and they get protection for it. And after FDA approval, they'll get 5 years of exclusivity if it's a new chemical entity. They'll get 3 years of exclusivity if it's a new clinical indication. But then in addition to the regulatory exclusivity, they have their patents. This is why you have your patents. This is why you work really hard with your patent attorneys. You have patents that protect the product that you list in the Orange Book. And you have a process of back and forth where generics want to now copy your product. They want to copy your product and they want to get on the market. You've developed a $1 billion product. People want to copy it. And so there's a back and forth between, there's a mechanism under this Hatch-Waxman litigation where a generic can come in and challenge the validity of your patent, and they can try to get your patents invalidated, and the patent owner has to defend that. The patent owner has to prove that the patent is valid and infringed by the generic. And if the patent owner wins, the generic drug doesn't get onto the market for years. If a patent owner loses, the generic can get on much quicker. There's a relatively newer set of litigations related to biosimilars, so antibodies, proteins, and the like, where a company develops a new biologic product, let's say an antibody, they get 12 years of regulatory exclusivity, but then within the system, you also have your patents, and there's a fight back and forth, a very complicated, what's called a patent dance of information exchange between the two parties, and a lot of litigation, very, very high value, high risk cases. ITC litigation, I think is the last thing that I'm going to address. The ITC, we're going out of our way to mention here, is not the biggest area of bio and pharmaceutical litigation in the US, but it's really important, especially if you're a non-US entity, because what the ITC does in a very fast time period, as I mentioned, is they can block someone from importing into the US an infringing product. and is a very patent owner favorable jurisdiction, and it'll literally stop your product at the borders if you lose. You can't lose money damages here. You can't have to pay money, but it'll block you from the US market. And it's a very, very powerful weapon for a company that has US patents and some domestic US industry to block competitors from getting into the US. Yi, I'm turning over to you now for the PTAB.
Thank you, Mark. And by the way, Mark told me to say hello in Chinese when I start the speech, and I forgot. So I want to say hello, 你好, hello. I can speak Chinese for sure because I'm from China. But anyway, so right now I'm talking about the PTAB practice. It's a different world compared to digital litigation. There are sort of two types of PTAB proceedings. One is called inter partes review. We call IPRs. The other is called post-grant review. We always call PGRs. Next slide, please, Mark. Okay, so first of all, I have to say those are kind of relatively new proceedings compared to digital litigation because they only became available since 2013. But since then, they have become very powerful and very popular tools for companies to use to challenge and invalidate the patents of their competitors as part of the freedom to operate a strategy, just to knock down the patents and you can sell the product anywhere in the US without worrying about infringing, right? So that's why usually you can see when there's digital litigation in the patent field, usually there are many times when the defendants, they file the PTAB proceeding, IPRs or PGRs, to challenge the patents or asserted patents in the cases in parallel. But if you choose to do that, you have to do that within 1 year after being sued. Otherwise, you're barred from raising those challenges. And talking about the grounds, what can you do in the proceedings? There are some differences between the IPR and the PGR proceedings, including what grounds you can use to challenge patents, and also including the timing of your challenges. For example, for PGRs, if you have a patent you want to challenge that was just issued, you can use PGR to challenge the patent because PGRs can only be used within 9 months of patent issuance. On the other hand, if it's an old patent and it's been issued for a while, then IPRs can be used after 9 months of patent issuance. And also for IPRs, you can use printed publication prior art to challenge the novelty and obviousness of the patents. So it's always based on the printed publication prior art. For PGRs, you can have more, as a broader scope, you can raise all patentability challenges, including novelty, obviousness, whether the patent is eligibility, or written description, enablement, indefinite. There are a lot of different tools you can use in the PGRs to invalidate the patent before the PTO, the PTAB. So why those are very popular? Because first of all, they're much cheaper than digital litigation and faster because PTAB practice proceeding, IPR PGRs, they have limited discovery, which means usually there's no document production. As Mark mentioned, you have to produce tons of documents. In digital litigation, you don't have to do that in PGR IPRs. There's no fact witnesses. Usually they're just like focusing on the validity, the merits of the case, which means whether the patent is valid or not. Their briefs filing, their depositions of the experts, and usually that's it. And after the exchange of briefs and expert declaration and expert depositions, there will be the oral argument before the PTAB judges. Usually there's a panel of 3 judges that's going to determine your case. After hearing the oral argument, they will issue final written opinion. And if you're unhappy about your loss, you can just appeal. So there are several different unique issues for PTAB proceedings. First is estoppel issue. To avoid the patent owners being harassed by the defendants by the defendants in both digital litigation and PTAB proceeding by repeating the same grounds of challenging. By law, if you have raised some grounds, or you could have reasonably raised some grounds in the PGR and IPR, you can no longer use the grounds in the digital litigation to challenge the patents as a defendant. So there is estoppel issue. You cannot use you can't repeat your challenges in both jurisdictions. Secondly, although everybody except for the patent owner can challenge patents through IPR, PGR proceedings, if you lose the case, not everybody have a standing to appeal the case. Only parties who have actual or imminent injury, potential injury, such as you will have a threat that the patent owner will sue you for patent infringement. If you don't have that kind of threat or potential harm, you don't have a standing to appeal your loss. Next slide. So IPR PGR proceedings share the same major phases. As you can see in the timeline, usually the entire case should be determined within 18 months. That's why it's faster than digital litigation, which usually takes over 2 years to finish the case. So in the IPR PGR proceedings, after petitions are filed, the patent owners can reply by providing preliminary responses. And then after 3 months, the board will decide whether they will even institute the case for further trial. If the decision is made that, okay, you did not see, you didn't, as a petitioner, you did not show a reasonable likelihood you can win the case, then the board has a discretion to deny the institution, and the entire case will stop here. And the decision of denying institution usually is not even appealable. Of course, after your petition is denied, petitioner may file a request for hearing and ask the board to reconsider their decision, but sometimes it would not work. So once the board decides, on the other hand, that the case can go forward, then within 3 months, the patent owner can file a response, official response, after taking the deposition of the expert of the opposing counsel. And then after 3 months of that, petitioner can file a reply to the response. And after 1 month, the patent owner can file a third reply. And then there's an oral argument. There are motion practice, limited motion practice involved here, usually limited motion to exclude. Also, the patent owner during this proceeding thinks, okay, maybe the petitioner is right, there too much prior art out there, or the claim seems to be very broad. Patent owner can always file a motion to amend in the proceeding to try to adjust the scope of their claims to make them stronger. And then after the oral argument, a losing party can still request for a hearing before the appealing to the Federal Circuit. So they always have a chance to try to persuade the board that the board's decisions are not proper or legally wrong before they appeal to the Federal Circuit. Next slide, please. So again, when I mentioned the limited discovery just now, I said it's limited to expert discovery. It's actually, that's why experts play an essential role in the IPR PGR proceedings, because they are the persons who represent the perspective, provide a perspective, a person of ordinary skill in the art to the judges, to educate the judges about the technology at issue and the entire background, like what was known at the time of the invention. Okay, and also they also wanted to tell the judges how the claims would have be understood by the persons in the art. For example, as Mark mentioned, there could be a claim construction hearing during the digital litigation. In the IPR PGR cases, the petitioner patent owners can also try to construe the terms in their briefs, and experts can provide support for each party's position, explaining to the judge how a PUSA would understand the meaning of the term and the scope of the term. Also, an important role of the expert is to tell the judges what the prior art, asserted prior art teaches, because that's going to tell the judges whether patent is novel or obvious over the prior art. So the prior art's teachings are important to understand. And also, particularly for the obviousness challenges, the expert will provide a POA, a person art's view on the motivation to combine the prior art and a reasonable expectation whether a person to art will have been reasonably expected to achieve the claimed invention based on the prior art. Those are, again, very important for the judges to understand the technology and invention and the prior art to determine the patent is valid or not over the prior art. And in this proceeding, testimony of the expert is limited to, first of all, written testimony by declaration. When I mentioned the timeline just now, when I talked to petitioner, filed the petition to start the entire process, usually the petitioners will already file, along with the brief, an expert declaration, again, to explain the position and further elaborate the reasonings behind the technical arguments. And again, we just got some very important decisions from the PTAB telling you that although you have expert to support your position, your expert cannot have conclusory statements in the declaration without supported by literature. And also the expert has to provide sufficient detailed technical reasoning to make sure that the board will give any weight to the expert's words. And another type of testimony provided in the proceeding is called deposition. As Mark mentioned, depositions are very common in digital litigation. The same kind of style is going to occur in the IPR PGR proceedings as well. There will be cross-examination with optional redirect, but the experts would not be allowed to give live testimony during the oral argument before the judge. So make sure, prep your expert well in the declaration and deposition stage, because when you argue before the judge, the expert would no longer be there. Next slide, please. So the interplay of litigation and IPR, as I mentioned just now, usually nowadays you see a lot of district court litigation has parallel IPR PGR proceedings, and for the defendants in the cases, IPR PGR provides a very good, very powerful tool for them to even take 2 bites of the apple, because if you can see from the slide show the timeline. When the fact discovery starts early enough in the fact discovery, if defendants just file IPR PGR against asserted patents before the PTAB, the district court will say, okay, the PTAB judges have the expertise to judge the validity of patents. So because many judges, they do patent cases and non-patent cases, and patent case could be too technical for some judges. So, okay, well, I'll just stay the district court litigation and wait for the PTAB judges to decide the patent's validity. So the district court case gets stayed, such that defendants can save money and effort and start focusing their effort and energy on the IPRs. And then the IPR PGR, as I mentioned, only takes 12 to 19 months. And then afterwards, the patent will be announced, that the claims will be announced patentable or unpatentable. If it's announced unpatentable, then it's a victory for the defendants, right? Because you knock down the patent and the case is, the claims are gone from the district court case, it's out of the case, because the district court judges would not deal with these claims anymore. But even if the PTAB find the patent's claims patentable, then the fact discovery stay, when it's lifted, you can go ahead and start litigate other grounds not raised in the IPRs. For example, for IPRs particularly, because remember in IPRs, you can only challenge based on novelty and obviousness and based on printed publication. But then when you lose here, you can go back to the district court and keep litigating the same claims using different grounds, such as written description enablement, and you can go to trial and determine further, try to knock down patents there. Eventually, losing parties can always appeal to the federal circuit. And that's why we think IPR PGRs, they're very popular because they became an additional tool for parties to use in addition to district court litigation. And anything to add, Mark? I think I'm done with my speech.
No, I think that's great, Yi. Thank you.
Thank you. We welcome any question from the audience if you have any. Oh, there's one question.
Yes, Go ahead.
Yeah, there's a question about the cost of litigation, and it varies a lot, and it depends somewhat on how hard the parties are going to fight. If the fight is over a truly $1 billion product, the amount of effort that both sides are going to put in and mount is going to be potentially huge. So maybe, in the order of $10 million or more per side, if you're fighting over the validity of a family of patents on a biologic product for $1 billion product, people will bring the resources, and the other side sort of has to match it. If you're talking about a smaller case, some cases can be in the very simple mechanical cases, maybe in the few $1 million range, and it just goes up from there as you go from 1 to 2 for a really simple case, maybe 3 to 4 to 5 for a medium product, and then it just continues to go, and it again depends on how hard the parties are going to fight. It's not something either party can fully control about how expensive the litigation is going to be.
Yeah, by comparison, that's why I think PTAB is much cheaper in that aspect, right? PTAB practices, I feel like usually, the budget usually $500,000 can get entire case, cover entire case, depends on technology. Biotech cases are more complicated and involves more effort from the expert to explain the technology. So that's why a little more expensive. But again, for simpler cases like mechanical or medical devices, it could be even controlled to be sometime below $500,000. Yeah.
And that's again why for the patent owner, a PTAB challenge, if you want to challenge the validity of a patent, is much cheaper to just attack a patent in the patent and trademark office. It's a fraction of the cost because there's no discovery and it's all one-sided. It's just validity, not infringement. There are also questions about jurisdiction and where the parties should choose jurisdiction. It's complicated in the US, and there are sort of two intertwined questions for an agreement. There's one question of, if you have an agreement, you can have that agreement a choice of law. Whose law should apply to interpreting the agreement? Strangely, in the US, the interpretation of an agreement can vary from state to state based on law they've built up over time. The most common jurisdictions used for interpreting agreements, people use New York and Delaware because they're experienced judges, and the laws have been pretty thoroughly vetted, and so you have a more certainty on how things are going to get interpreted if you have choice of law based on New York law or Delaware law, maybe California law. In terms of where to litigate, you can only sue someone unless they've agreed to it. You can only sue someone where they are either infringing or basically have or incorporated or have a facility. And so Delaware and New Jersey are very common. Texas, in less so for biotech cases, but for non-biotech cases, Texas is a big place to sue for infringing automobiles, infringing technology, because the juries tend to give very high damage awards in Texas. And so it's a very complicated process trying to figure out where you can sue and where you can be sued. Delaware, New Jersey, Texas are among the most popular. There's some reason in Virginia, where I live outside of Washington, D.C., there's a very fast court that some people try to use if possible, but it's a very complicated situation figuring out where you can actually sue in the US. I think that's all the questions that have come in, and I think we've kind of hit everyone's time for their Saturday night. Can we turn it back to you, Kirsten?
There's one more question.
Oh,
You want to answer this one, Yi?
yeah, sure. The question is, challenge the patent and was successful after 2 years. Oh, you mean during during the PTAB proceeding? Yes, the patent remains active and alive and enforceable during the PTAB proceeding. So, but again, the PTAB proceeding is not over 2 years. I feel like the PTAB proceeding, if it's a PTAB proceeding, it has to be finished within 19 months from the start to the end. So it's like 1.5 years. During the process, I mean, if there's a district litigation, you can always ask for a preliminary injunction. The patent owner can ask for a preliminary injunction, but if you're talking about as a defendant, right? As a defendant, yes, unfortunately, the patent still remains active until it's invalidated. That's a very high level conclusion. Mark, do you agree?
Yeah, that's it's true, but it may or may not have an effect. If you're sued for infringement and it takes 2 years for you to prove the patent's invalid, you may be able to keep selling during those 2 years. The patent owner would have to do something to get a preliminary injunction against you, but you may be able to keep selling for those 2 years that it takes for you to invalidate the patent. And if you've done that, if you've been selling and it takes 2 years for you to invalidate the patent, you won't be liable for any damages. So the patent is technically in force, but if it is found to, after 2 years, to be invalid, you can't owe any money for that 2-year period where it was in force before it was proven to be invalid. I hope that answers your question between the two of us.
I have a question for you, Mark, though. So there's sometimes willful infringement assertions, right, in district litigation. So my patent's out there, you still infringe, and that gives triple damages for the patent owners. But when you start the IPR proceeding, I assume your sales during this process, it would now be accused of willful infringement, right? Because you're challenging, you don't believe the patent's invalid. That's why you're selling. Talking about damages.
So I mean, that would be, you would certainly have knowledge of the patent.
Yeah.
If you're challenging,
but you don't think it's valid.
And you might have a good faith belief that the patent's invalid, and that good faith belief that the patent is invalid is reflected in the position you take to try to invalidate in the IPR. But then you lose the IPR, and the question was, well, how good was your good faith belief or not? So sure. Yeah, I think that challenging an IPR can show evidence that it's not willful infringement, because you have a substantive challenge to the patent that you stood behind, and the patent office at least initiated the review, and it could be helpful that way, as long as it actually is a decent position.
Yeah, yeah.
Okay. Oh, thank you, Mark and Ye, for your great analysis, and thanks everyone for attending. If any questions come in, I guess we'll pass them on also for answering if that's possible. But again, thank you to everyone who dialed in, and enjoy the rest of your day. Thank you very much.
Thank you.